I now request our chief guest, Honorable Ms. Justice Indu Malhotra, Judge, Supreme Court of India, to kindly address the audience.
I am honored to be invited to deliver the keynote address on the arbitration landscape in India as a part of the Nani Palkiwala birth centenary celebrations. Nani Palkiwala has been one of the greatest constitutional jurists post-India whose contribution to constitutional law and income tax is unparalleled. During the peak of emergency, he fearlessly fought for an independent judiciary which would safeguard the fundamental rights of citizens against the excesses of the executive. One of his favorite quotes from Joseph Story, an American jurist, was, and I quote, "It depends upon the present age whether the national constitution shall descend to our children in its masculine majesty to protect and unite the country, or whether shorn of its strength, it shall become an idle mockery and perish before the grave has closed upon the last of its illustrious founders." He believed the Constitution is intended not merely to provide for the exigencies of the moment, but to endure over the ages. In the Privy Council case, he was appalled at the action of the government in passing a midnight executive order de-recognizing privy purses. You heard a snippet of it just now a little while ago. Mr. Palkiwala reached the zenith of his career when he propounded the basic structure doctrine in the Keshavanand Bharti case, which was upheld by a slender majority of 7:6. Simply put, he propounded that Parliament, in exercise of the power to amend the Constitution, cannot alter or destroy the basic structure or framework of the Constitution. According to Palkiwala, the essential features which constitute the basic structure of the Constitution are the supremacy of the Constitution, the sovereignty of India, the integrity of the country, the republican form of government, the democratic way of life, a state in which there is no state religion, a free and independent judiciary, the dual structure of the union and the states, and the balance between the legislature, executive, and the judiciary. None of the three organs can use its power to destroy the powers of the other two, nor can any of them abdicate its power in favor of another. Today, I do want to recount one, in fact, which is considered to be the best oratory of Mr. Palkiwala in the Supreme Court when the Keshavanand Bharti case came up for review, and I'm going to recount that. Of course, I was not there. I have derived my knowledge from my father, who was present in the court. An article written by Mr. Fali Nariman in the Times of India about 8 years ago. Then there was another article written by Tempton and Dharujina in one of the new, I think it was in the Indian Express, and there is a passage about it in his in Sirvai's Constitution of India. In fact, you would be surprised, but it's not chronicled in the annals of the court record. So, you know, I have fixed all this together, and I thought it would be an interesting topic to speak about before I introduce my subject. This was after the supersession of the three senior-most judges, Justice Shellett, Hegde, and Grover, that Justice Ian Ray assumed office as the Chief Justice of India on 26 April 1973. Before the judgment in the Indira Gandhi election case was delivered on November 7, 1975, an application was moved by the Attorney General and the Advocate General of Tamil Nadu seeking directions to list a bunch of writ petitions seeking reconsideration of the Keshavanand Bharti case. Chief Justice Ray indicated that the writ petitions would be listed for hearing before a 13-judge bench on 10th November 1975 to consider whether the basic structure theory as propounded in the Keshavanand Bharti case restricted the power of Parliament to amend the Constitution and whether the bank nationalization case was correctly decided. Just prior to the hearing of the petitions to reconsider the Keshavanand Bharti case on 10th November 1975, 4 out of the 5 judges of the Supreme Court in the Indira Gandhi case clearly reaffirmed the basic structure theory by rendering a decision on the 7th of November 1975. 3 days later, a new 13-judge bench was assembled to reconsider the decision in Keshav Nand Bharti. The hearings before this bench lasted for a little over 2 days. Nani addressed the court, and the two sentences which my father would recount on many an occasion was, "Gentlemen, you will rue the day if you let down the people of this country by reconsidering and reopening the Keshav Nand Bharti case. Posterity will never forgive you for this." After 1.5 days of presentation, 12 out of the 13 judges were convinced by his arguments. They told the then Chief Justice of India that since there was no live issue to consider and the hearing of the case would take 6 months, it would be a waste of time. On the third day, that is 12th November 1975, the Chief Justice announced this bench is dissolved. Ever since, the basic structure doctrine has stood the test of time. Nani cited another beautiful quote of Joseph's story, which I'll read to you a little later, but Justice H.R. Khanna, in his memoir, paid the most handsome tribute to Nani when he wrote, "The heights of eloquence to which Palkiwala had risen have seldom been equaled and never been surpassed in the history of the Supreme Court." My personal interaction with Mr. Nani Palkiwala was for the first time when I had accompanied my senior Mr. P.H. Parekh to brief him in what was called the PME case, a constitution bench case on post-manufacturing expenses. And after that, when I started my independent practice, when I think I was just about 4 years at the bar, I had taken an appointment from him at Tata House seeking a written opinion on an income tax issue. Apart from his brilliance in comprehending the issue within a few minutes, I was actually overwhelmed by his extreme courtesy towards women. He rose from his chair when I entered, and when I left, he came and held the door for me to leave the room. He was an extremely courteous man. Apart from his brilliance, etc., there was no arrogance to him. Now, with respect, now I will get on to the subject of arbitration and Mr. Palkiwala's thoughts on it. He, in a lecture which he had delivered on the 125th anniversary celebrations of the Bombay High Court in Nagpur, commented that the greatest drawback of the administration of justice in India was the delay in disposal of proceedings, given the mind-boggling number of cases pending in the courts. One of the suggestions he mooted was that arbitration must be made compulsory in commercial matters. He commented, "My own experience of national and international arbitration gives me great confidence in arbitration as an alternative superior to litigation. If I were appointed the dictator of a country in the short period between my appointment and my assassination, I would definitely impose a law making all commercial disputes compulsorily referable to arbitration." Now, coming to the arbitration landscape of India, the precursor, as all of you know, of the 1996 was the 1940 Act, which was framed to govern domestic arbitrations, while for enforcement of foreign awards, we had the Arbitration Protocol and Geneva Convention Act of 1937 and the Foreign Awards Act of 1961, which governed awards under the New York Convention. The promotion of arbitration was also discussed in the Constituent Assembly debates, and Mr. B.M. Gupta had contributed to this, saying that arbitration is an essential. I'll just read a few lines. He said, "I think it would have been better if we provided that arbitration should be resorted to if we want to avoid war. We should hold out some substitute for war. Naturally, there cannot be a better substitute than arbitration. International players are never going to take recourse to our municipal courts. They will always want a neutral body to adjudicate international disputes, and that is why the relevance of arbitration. in the Constituent Assembly debates, Mr. Ananthasam Iyengar had also suggested the amendment to add Clause D to Article 51 of the Directive Principles to encourage settlement of disputes by arbitration. Now, the 1940 Act, which remained in force for almost 56 years, became prolix and time consuming. It took years for people to get the award made a rule of the court. One had to move the court to get it made a rule of the court and get it enforced. And as Mr. Parikh pointed out to you all, it took almost, in fact, sometimes decades for the whole gamut of appeals to go through, and a person, by then one did not know also if a person would get the fruits of the award. An interesting comment was made by Justice D.A. Desai in Guru Nanak Foundation, and I would like to read that to you. He says, the way in which the proceedings under the Act are conducted are without an exception challenged in courts, has made lawyers laugh and legal philosophers weep. Experience shows and law reports bear ample testimony that the proceedings under the Act have become highly technical, accompanied by an unending prolixity at every stage, providing a legal trap to the unwary. In the mid-1990s, post-liberalization of the economy, the UN General Assembly adopted the UNCITRAL Model Law of Arbitration. The model law was not a treaty or a convention, it was a legislative template for states to model their arbitration statutes. India enacted the 1996 Act on the basis of the UNCITRAL Model Law, but with some modifications which were to adapt it to the local conditions endemic in this country. It was framed as a consolidating act to cover both domestic arbitrations and for enforcement of international awards. In fact, it is my view that I think there should always be two separate enactments, both for domestic arbitration and enforcement of foreign awards, because sometimes, in fact frequently, it leads to odious comparisons being made frequently by the court while interpreting provisions of comparing one with the other, and that is why I think this is what had resulted in the judgment in Bhatia by applying provisions of Part 1 to Part 2, and it took 9 years before Balco came in and rectified it, and India became the object of serious criticism by international practitioners who felt that it was dangerous to come to India as a seat of arbitration or to have disputes resolved in this country. India's rating really was low in the World Bank rating of ease of doing business with this country. The second thing which I do want to comment on, the 96 Act was brought in through the ordinance route, and the benefit of public discourse and debate in Parliament by all parties was lost. I don't think that is an ideal way of bringing about a legislation, although it's a valid method, but there are several lacuna which do creep into a legislation, some of which could have been avoided or mitigated. Of course, there is no legislation which is perfect, and it evolves as we work the acts. The 1996 Act had worked for almost 2 decades when several lacuna were found in the Act. One was permissible extent of judicial intervention in arbitrations, particularly at the pre-reference stage, arbitrability of certain kinds of disputes, enforcement of domestic and foreign awards, etc. That it was in 2015 that the most significant change came with the passing of the 2015 Amendment Act, which was on the basis of the 20th Law Commission under the chairmanship of Justice A.P. Shah, who conducted a thorough review of the working of the Act and published the 246 report, which suggested wholesale changes which were practical to the existing regime to bring arbitration legislation in sync with contemporary international practices. The recommendations were aimed at minimizing judicial intervention, yet increase judicial support in the conduct of arbitral proceedings. Unfortunately, this act was also brought through the ordinance route. Although it was based on the 20th Law Commission, I don't think it's a good idea to bring legislation through ordinance. It should go through the gamut of debates in Parliament because it always helps in refining a legislation. But 2015 has been a very, very successful amendment. It has streamlined the entire arbitral process. The first important thing which has happened is that it has reduced judicial interference at the threshold. The only issue to be examined at the stage of reference is whether there is an existence of an arbitration agreement and no more. This was brought about to overcome the 7-judge decision in Patel Engineering, Bogara Polyfab, Master Construction, and several other decisions which had said that several issues have to be decided at the threshold at the pre-reference stage. So the arbitration would never take off the ground until these issues were decided by the courts. The second important thing, which was that Section 29 capital A introduced a timeline within which arbitral proceedings would be concluded. However, and for an extension one had to go, 6 months was consensual, after that to the court. However, no outer time limit was given to the court for exercising its discretion as to whether further extension ought to be granted or not. This is one of the lacuna which exists in the 2015 Amendment Act. In fact, my view is that it has in a way resurrected the regime under the 1940 Act, because you have to again take recourse to the court at the pre-reference stage, which is not a good idea. The entire purpose, what is the leitmotif of arbitration? It is party autonomy and minimize judicial intervention. If you have to go at the threshold to the court or at an intermediate stage of the proceedings, if you have to keep harking back to the court for extensions, it militates against the entire process of speedy resolution of disputes. And thirdly, what happens to the arbitral proceedings when you approach the court? Do they remain in limbo? This is an issue which remains to be ironed out. Another important significant amendment which was brought about was to empower the arbitral tribunals to provide effective interim relief under Section 17. However, there has been an error in that section. It has replicated Section 9, so far so good. But it further provides that after the making of the award, before it is enforced, the arbitral tribunal may be approached for grant of interim measures. Now this is contrary to Section 32, because once an award is passed, the arbitrator or the tribunal becomes functus officio. Therefore, it cannot pass any directions post the termination of the arbitration proceedings, which comes with the pronouncement of the final award. So this is one other issue which requires to be rectified. Then the 2015 amendment has minimized judicial scrutiny into the merits of the award at the Section 34 stage. The definition of court in Section 21E has been amended with respect to international commercial arbitrations by vesting jurisdiction in the high courts. Significant amendments have been made with respect to independence and impartiality of an arbitrator. This in fact is particularly important because in most arbitrations with government entities, PSUs, they would always have one of their employees to act as the sole arbitrator, and the contractor had no option but to sign on the dotted line. And frankly speaking, this completely undermines a fair process, because you undermine the principle of neutrality. You need a person who's neutral, who's independent of the parties, to provide a fair award. This has now been rectified. In fact, India has gone, I think, several steps ahead of foreign jurisdictions by incorporating the IBA guidelines as a schedule in the Act. Most foreign jurisdictions treat it as soft law. They have not incorporated it, given its statutory flavor. The 2015 amendment now provides a list of relationships which would disqualify a person from the appointment as an arbitrator. Now I also want to touch upon the judicial perspective. I think in the aftermath of the White Industries case, which came recently, although it was in the context of investment treaty arbitration, I think the courts also did get a shock that pendency of proceedings in the court would cost this country heavy and a huge burden on the taxpayer. The judicial pronouncements which have come of late, several judicial pronouncements by the Supreme Court, have been pro-arbitration and have been appreciated by foreign practitioners. Like in Centro Trade, the court accepted a two-tier arbitration, even though in the first tier it would be a domestic award and in the second tier it would be a foreign award. The court said no, we will respect party autonomy. If that is what the parties agreed, so be it, and they upheld the two-tier arbitral mechanism. Then in Cheran Properties recently, a 3-judge bench, while resolving a corporate dispute, have upheld an award where transmission of shares could be enforced through a statutory tribunal, which is the NCLT. I thought it's a very, very progressive judgment. Roger Shosua is another one where parties had not specified a seat but a venue. The court said that it seems as if the parties had wanted the venue to be the seat, and they upheld that provision. In fact, now we have passed a judgment that there is no requirement for stamping of foreign awards. The courts have also said no, LPA is maintainable, arbitration is a self-contained code, and even in the context of the Commercial Courts Act, wherein there were 2 judgments, but I think Supreme Court has now clarified in Kandla Corporation, wherein it has now been held that even you can't take recourse to an appeal under the Commercial Courts Act. Bar Council of India is another important judgment which has recognized the importance of promoting India and has allowed that there would be, and has in fact recognized that there would be no bar for foreign law firms or international practitioners to appear in arbitration in India on a fly-in, fly-out basis. Now, hardly had the ink dried on the 2015 amendment that the government was in a progressive frame of mind that they constituted the Sri Krishna Committee for institutionalization of arbitrations, because most arbitrations in our country were being conducted through ad hoc arbitrations, and they felt that it was necessary to promote a centralized institution which would make India a hub for arbitration, whether in domestic, and of course domestic has to be taken care of, and international arbitrations. In fact, there are a myriad institutions in this country which take care of domestic arbitrations, but particularly for international arbitrations, India was very, very keen to make it an attractive destination for international arbitrations. So I was a member of that committee. We had recommended the setting up of a statutory body called the Arbitration Promotion Council, which would have representation from various stakeholders. And I want to emphasize this because in the 2018 bill, they had gone and made it more government dominated, government controlled, and there has been serious criticism of it. Even though the bill has lapsed, our recommendation was that there has to be representation of various stakeholders from industry, etc. And we did not want any of these institutions to be controlled by the government, since government is one of the major participants in these proceedings. We had also, this institution was to provide training through workshops, maintain an electronic depository of arbitral awards. Now, I do want to explain this to you for a moment, because there has been criticism from international practitioners on this recommendation. This recommendation came about because there were various retired Supreme Court and High Court judges who came and appeared before us and told us, they said that if you don't have a depository, most of them were appointed in our ad hoc arbitration. They said, what do we do with the record? What do we do? We can't keep maintaining it. So we decided that there should be an electronic depository to maintain the record of in arbitration proceedings, so that if subsequently in courts you require it, it is accessible, because otherwise you can't expect arbitrators to keep retaining the record for an endless time. And this was not meant, it would not really infringe confidentiality, which is one of the apprehensions. It is to be maintained in a depository in electronic form, and no one really gets access to it. We also provided for accreditation of arbitrators to build a pool of qualified and experienced arbitrators, develop an arbitration bar, and train judicial officers to understand the supervisory jurisdiction of courts in an arbitral process, not to treat it as a challenge under the challenge under section 34 as a regular appeal. That perspective has to be imparted to them. We recommended also various amendments to the legislative amendments, and I won't repeat those because most of them I have touched upon while criticizing the 2015 amendment. We also suggested that arbitrators must be provided immunity from acts or omissions in the discharge of their functions. In fact, world over in all legislation, they are provided this immunity. And so we had recommended this, and the 2018 bill had accepted this recommendation. We had also suggested that there should be emergency arbitrators and enforceability of emergency awards by amending the definition of award into 1C. The 2018 amendment bill was introduced, as everyone knows, in the Lok Sabha. It has lapsed. It was not passed through the Rajya Sabha. It has lapsed. And the criticism, Lord Peter Goldsmith and one or two other foreign commentators have had three major criticisms. One is that the constitution of the Arbitration Council is a governmental body with wide-ranging powers to regulate arbitration. They feel that it will unnecessarily interfere with party autonomy and the autonomy of arbitral institutions to conduct proceedings. In fact, the constitution of the Arbitration Council is really not what we had recommended in the Sri Krishna Committee. Second was their criticism of the proposed depository. And the third, where I do agree with Peter Goldsmith, is the proposed 8th schedule, which provided for qualifications and experience of arbitrators. It has certainly some serious major omissions. It excludes QCs, foreign advocates, persons of commerce, etc., which might cause various problems, because this was seriously objected to by international practitioners. Even though in A.K. Balaji, the Supreme Court has accepted that arbitration practitioners can come and appear on a fly-in, fly-out basis, but this amendment would be a major setback. Now, with the bill having lapsed, and if it's reintroduced, I hope there will be public discussion and it would not be introduced through the ordinance route. There are other areas to be addressed, and some of my suggestions are, even though the World Bank, we have in fact after the 2015 amendment, we have leapfrogged at position 77 amongst 190 countries. We have gone ahead by 23 ranks in World Bank's ease of doing business in the 2018 rankings. However, with respect to enforcement of contracts, we still rank at the 163rd position. So I think it is time for us again to buckle up and not become complacent. I think legislative amendments have to be reviewed periodically rather than after a time lag of 20 years, which happened in 2015. Secondly, I think the important thing, even I am a part of the judiciary, but I think there is some suggestion which has to be made, and I think it has to be enforced all through the high courts. That is, there are three provisions which were introduced by the 2015 Amendment Act. One was section 11 subsection 13, which provides a period of 60 days for disposal of applications. Of course, it's a directory provision, it's not mandatory, but I think these timelines must be observed, otherwise arbitration will not take off the ground for a long period. The second one is 29 capital A subsection 9, which provides a period of 60 days from the date of serving of notice on the opposite party that the court will dispose of an application for extension of time. Third is section 34(6), which provides that an application under 34 shall be disposed of within a period of 1 year from the date on which notice is issued on the other party. These are three important timelines, and I think the courts must adhere to it, even though these are obviously directory provisions. They are not mandatory, because if you treat it as there's a judgment which Justice Nariman and I had delivered on this, that these are directory provisions. If you consider it to be mandatory, you will be scuttling the entire process of the enforcement of awards. The last thing which I do want to say is that high courts have not notified rules under section 11 subsection 14 with respect to fees of arbitrators, which is still very important. Arbitrators cannot be let loose to keep charging the fees which they please, because it was meant to be and not only an expeditious but an economic mode of dispute settlement. Lastly, I think there is one issue which needs to be addressed, which I find, which is a complaint which I have got from various Indian practitioners in international arbitrations. Indian judges normally are appointed as arbitrators in these arbitrations, but it's very important to train them as arbitrators. You have to take off the cloak of being a judge when you are an arbitrator. You have to be pragmatic, you must have a commercial sense, you have to liaise with the arbitrators so that you come out with a good award. You can't stay in, on an Eiffel Tower and think that things will work out. You are not a judge, you are an arbitrator. There are commercial disputes to be resolved, so that pragmatism has to come. And the other two aspects which I feel Indian arbitrators suffer from are about computation of damages, leveling of costs. These are important aspects which one hasn't done as a judge. I think they require more training, particularly in international commercial arbitrations, because frequently most of the international awards with respect to India have been 2:1, where the minority arbitrator has been an Indian judge. And of course, we don't want to lose in these arbitrations. We need to train our arbitrators better to get more effective results. Thank you.
Thank you for a truly enlightening lecture, ma'am. We are throwing the house open for questions and answers. I now request Major General Nilian Kumar sir to kindly present the questions on behalf of our audience.
We have received two questions, and I would request the first person to put up the Chan. Yeah. First was by Advocate Meenakshi Rawat. Where are you? Yeah. Would please take the cordless mic and be brief, ask your question directly.
Good evening, sir. My question is why the Arbitration and Conciliation Act, the Amendment 1, still fails to achieve the completion of arbitration proceedings within a specific time period when it is specifically written in the Act that it should be completed within time.
Earlier to 29A, there were arbitrations. I've appeared in a matter where the arbitration went on for 15 years with 1,000 hearings. 29A was introduced in order to stop this. It's like a bludgeon, and it has had a huge impact on the ground. Now our Indian arbitrators in domestic arbitration actually really try hard to complete it within 1.5 years. So practically it has made a big difference on the ground. It's a major problem which has been really tackled by this, and let me tell you, it's not an Indian problem. When I went to Singapore and mentioned 29A, as typically Singaporeans say, everything is great with them and everything is bad with India. But one gentleman quietly came and told me, sir, this is such an important provision. We have a retired Chief Justice of Singapore who's not delivered an award for 3 years. So it's a worldwide problem, and I think 29A, otherwise very controversial, has worked extremely well. It's not perfect, but even this 1.5 years has put a lot of pressure on arbitrators, and people have changed. I mean, retired judges, Supreme Court, High Court judges, definitely the pressure is on.
Thank you. Particularly because the arbitrator is today required to give a declaration of his availability on time. It's a statutory disclosure and declaration he has to make, so you can't just keep piling up work and not dispose it.
Thank you. Thank you, ma'am.
My question is it time that we have a bar which is dedicated for arbitration as opposed to litigating lawyers?
It's certainly necessary, but it's not that, you just say that an arbitration bar should be created. It will grow when you have full-time arbitrations in Delhi or in any part of this country. The arbitration bar starts growing itself. That's how it will happen.
I happened to read your father's book many years ago. But today, after hearing you, I find that you have said that so many amendments have been done. Now, latest one is going after Lord Krishna, Justice Krishna's amendment. You have been talking about that. we are more keen on amendment, not creating a atmosphere of justice with the people at large. You can see, I give you now, Government of India, as early as 1964, took a steps to create a committee, an Indian Council of Arbitration was created, with the purpose that it can be adopted by everybody else, or rules for it. But over the years, that ACA diluted, where I had been for a number of years, and I find some of the judiciary members become part of the arbitration committee, they want to take cases themselves. These are the issues which are more important. Along with that, we do an amendment. The 2006 amendment to the model law, Article 2A, which says our approach should be in international line and zero odds. We avoided that. There are certain other gaps when you see. When you take the model law, we should be fully following it. We are leaving halfway. So I personally feel, the other thing you have said, the arbitration law should be put on the net. I think arbitration is confidential. Unless both parties agree, then only you should be able to put it there itself. Now, there are European cases of that. Now, the rest is on section 12, subsection 5. You have a proviso that if parties both agree,
Sir, kindly ask a question.
everything can be waived. So you can tell us, section 12, subsection 12, that subsection 5 of section 12. To you, how can you do that? My question is that to you, that unless you create a culture, it will be difficult. Except section 12, subsection 5, proviso. Do you think it is necessary?
People only practicing in arbitration, both the arbitrators and the lawyers who appear, in case even non-lawyers can also appear.
If the arbitrator gives the judgment reserved for more than 6 months, then in human consistency, the outcome of the Supreme Court that the order should not be valid. In case if I am going to the courts are not adhering to that very judgment. They said it is in some other parlance, not in the arbitration. Can it not be enforceable for 34 proceedings also?
Reserve awards for a long time, but whether that's a ground to set aside an award is really still an open question. And we'll have to see, we'll have to look at the facts of each case and then decide how that works.